Let's talk a little bit about subject to for real estate. This is when a buyer buys a property subject to the existing mortgage on that property. So rather than replace the seller's mortgage with the buyer's own, the buyer instead is effectively assuming the mortgage of the seller. However, there are plenty of things to consider here. I'm working on a transaction right now with a subject to element to it. Now, at a very high level, it's just like any other real estate transaction where the seller is selling the title or is transferring the title to the property to the buyer. But there's the added wrinkle of it being a subject to transaction. Everything else looks very similar except for that little narrow part that ends up being very important because of the things that it can cause. And one of the biggest things to worry about when it comes to a subject to deal is the due on sale clause. And what I mean by the due on sale clause is this very specific clause that is in just about any mortgage where it's going to say that whoever holds that mortgage has the right to call the note, to call the loan due in the event that the property changes hands. This is to protect the holder of that mortgage, to protect banks, lenders from someone selling a property and then they still have the debt attached to it. So now this bank has to deal with a brand new person that they didn't do any vetting on, that they didn't do any credit checks or all that stuff, at least that the original owner had to do in order to get the mortgage in the first place. So it's a way to protect lenders, it's a way to protect mortgage holders. It makes a lot of sense. Now, the thing about the due on sale clause is it generally just gives the bank or the lender the option to call the note due. It doesn't mean they have to. And because it's generally just an option, this leaves a lot of room for what could potentially happen with a subject to deal, because the bank may or may not exercise the due on sale clause, whether the person is making payments on that loan or not, because the bank has the option. So you're never really going to know what's going to happen here. But it does raise the question, what happens if the bank actually does call the loan due? It's a very major consideration that both sides have to work out beforehand. What's going to happen if the bank calls this note due? Are we going to have some sort of alternative arrangement? Are we going to have someone have to go get another mortgage? Are we going to send the property back to the old seller and then again do some alternative arrangement? There's a lot of things you could potentially do here, but the fact of the matter remains is that it makes a lot of sense to figure out what you're going to do before you get into this sort of arrangement, because that due on sale clause risk is there, and there are plenty of other risks. Just like any other deal, there's always risks associated with a specific deal. That's why it helps to get specific legal advice or financial advice or just professional advice in general for your specific situation, because everyone's situation is different. This is just more food for thought on some of the things to potentially think about depending on what's going on with the deal. But in many cases, you really want to work this out. What happens if the bank calls the loan due? Work out those alternatives. What are you going to do in that case? That's both on the buyer side and the seller side, because you're effectively both still in this deal after the buyer buys the property, because it's still the seller's loan and it's the seller's credit on the line, generally speaking. So you really want to make sure that you get this right, or at least work through what those alternative situations might be and try to figure them out before they actually happen. That's the whole point of a contract. That's the whole point of writing things down. It's making sure that when you actually get to that emotional situation or that stressful situation, it's already all written out in black and white, ideally, and it's clear if it's drafted well, and whether it favors one side or another, whatever, just the fact that it's drafted there will kind of predetermine what should happen in the event that something like this happens. Now, moving on, what happens if someone doesn't pay? Again, thinking of the alternatives, thinking of the different situations. This is really what contract drafting is all about. You're working through the potential situations that could come down the line, especially these bad ones. What happens if something bad like this happened? If the buyer doesn't pay the loan for some reason, or however you're arranging how these loans are being paid or how the existing loan is being paid. Maybe it's through an escrow account that then goes to pay the loan after that. So there's kind of a third-party mediator in between there, or whatever the arrangement ends up being with a subject to deal. There's a lot of flexibility that you can build in here, but whatever the case, you want to know what happens if someone doesn't pay. So you want to discuss this with the seller, you want to discuss this with the buyer, whoever it is. Just make sure that you know what happens if something bad happens like that. Among many other situations, it's just one potentially common one. And just consider other alternatives as well. A subject to deal might not be the best thing for the situation. Again, every situation is different. It's hard to say without knowing the specific details of the specific deal, but just consider other alternatives. A lease option might end up getting you to nearly the same result with potentially less risks, or at least the risks are different. You don't have that due on sale clause necessarily, but Now you have a different sort of risk where it's a landlord-tenant relationship. What happens there? But there's no reason to force a subject to deal if that's not the best thing to do relative to the potential risks, because there are risks with any sort of arrangement, and what risks make the most sense for an individual person are going to differ. And what I mean by a lease option down here would be where the buyer leases the property from the seller, but in that lease, the buyer has very specific rights in what they can do with the property that kind of makes them able to act like an owner. However, in the meantime, the actual legal title to the property is still in the seller's name, and that thus should avoid the due on sale clause. Now, it might trigger some other problems if the loan doesn't allow the person to rent it out, but whatever, that's just another thing to consider. But it's a potential arrangement that could work. And the option part of that lease would be there'd be a future option for the buyer to actually purchase the property at a later date at some predetermined price or whatever the terms of the option are. Just another potential way to kind of get to the same end result. There are lots of different ways to get something done when it comes to real estate, but as always, you want to make sure you're weighing your different opportunities. But these are just a few things to potentially consider with a subject to deal. Like I said, I was recently going through one of these with one of my clients, so I was working through some of these scenarios or potential outcomes that could happen and how we would want to address those, and then going to the other side with those concerns and with those potential scenarios and trying to work out an agreement from there. I always like these deals where you have to think a bit more creatively to try and get to the end result. It just is a fun exercise in trying to weigh all the scenarios and get to an end result that's advantageous for everyone, obviously keeping my own clients in mind first. But anyways, if you found this video helpful, definitely let me know, and I'll see you in the next one.